brief update on recent tribunal decisions as at 25th of June 2019 on the IR35 legislation, which concerns the hypothetical employment status of individuals. Many of you watching this will no doubt be concerned with persons receiving services from individuals and who are trying to plan for the new legislation coming into force from 6th of April 2020. Under that, the burden will be on clients to establish whether the individual would be treated as an employee under the hypothetical contract constructed under IR35 and to deduct PAYE. You may, of course, be involved in a current dispute with HMRC about employment status, or you may just be interested in these particular cases, as the press have been, because they involve determinations and NIC decisions on personal service companies, or PSCs for short, of BBC and ITV presenters. So the first decision out related to the Look North news presenter Christa Ackroyd. HMRC won that case in the tribunal, which decided that under a hypothetical contract between her and the BBC, she would have been an employee and not self-employed. But HMRC have recently lost two cases, one against the PSC of Lorraine Kelly, that's called Albertel, in relation to her ITV presenting of Lorraine and Daybreak, and one against the PSC of Kaye Adams, that's called Atoll House, in relation to her BBC radio show, the Kaye Adams programme. I was counsel for Atoll House, in which the tribunal decided that Miss Adams would have been self-employed under the hypothetical contract constructed by the tribunal between her and the BBC. What I plan to do in this webinar is briefly to describe the key legislation and case law tests and how they were applied to the facts in each of those three decisions. So the purpose of the legislation has been described by Walker LJ, as he then was, in the Professional Contractors Group case, as being to ensure that individuals who ought to pay tax and NIC as employees cannot, by the assumption of a corporate structure, reduce and defer the liabilities imposed on employees by the UK system of personal taxation. It follows from this purpose that if, once one ignores the corporate structure, the relevant worker should have been regarded as an employee of the client, then the IR35 legislation is in point. And that's reflected in section 49 of ITEPA, which applies to an engagement if three conditions are met. 1 and 2 are that the individual personally provides services through an intermediary. The third condition is that the circumstances are such that if the services were provided under a contract directly between the client and the worker would be regarded for income tax purposes as an employee of the client. Section 49.4 states that the circumstances referred to include the terms on which the services are provided, having regard to the terms of the written contracts forming part of the arrangements under which the services are provided. 2 points to note. Firstly, circumstances include but are not limited to the terms on which the services are provided. So the wider circumstances of the individual's profession are relevant, and that will include whether the person is in business on their own account under the case law. And secondly, that regard is to be had to the terms of the written contract between the client, i.e. the BBC or ITV, and the personal service company, but they're not determinative. But not only are the written contracts not determinative, the employment case law dictates that the clauses in a written contract are not necessarily the terms of the contract. So we have to establish what the true contract is by reference to the reality rather than to the written agreement. The leading authority for the correct approach to take in establishing the terms of a service contract with an individual is the Supreme Court case of Autocleanse and Belcher in 2011. Per Lord Clark, in that case, the correct question to ask in order to establish what the agreement is what is the true agreement between the parties? As to whether the individual is in business on his own account, the tribunal is bound to take the approach taken by the courts in a particular tax case involving a vision mixer, that's Hall and Lorimer, which is cited by the FGT in all of these cases. The relevant passage at page 216 cites the judgment of Mummery J in the lower court, and I'm going to read it out because, in my view, it really rams home the difficulties from a risk management point of view in trying to establish someone's employment status. So the passage says, in order to decide whether a person carries on business on his own account, it's necessary to consider many different aspects of that person's work activity. This is not a mechanical exercise of running through items on a checklist to see whether they're present in or absent from a given situation. The object of the exercise is to paint a picture from the accumulation of detail. The overall effect can only be appreciated by standing back from the detailed picture which has been painted, by viewing it from a distance, and by making an informed, considered, qualitative appreciation of the whole. It's a matter of evaluation of the overall effect of the detail, which is not necessarily the same as the sum total of the individual details. Not all details are of equal weight or importance in any given situation. The details may also vary in importance from one situation to another. The process involves painting a picture in each individual case. As Vinelot J said in Walls and Sinnott, in my judgment, it's impossible in a field where a very large number of factors have to be weighed to gain any real assistance by looking at the facts of another case and comparing them one by one to see what facts are common, what are different, and what particular weight was given by another tribunal to the common facts. The facts as a whole must be looked at, and a factor which may be compelling in one case in light of the facts in that case may not be compelling in the context of another case. So I suppose there are three key points to note in terms of the correct approach. The relevant factors will vary from case to case. The weight given to the factors will vary from case to case, and no assistance is gained from comparing one case to another. Furthermore, whilst a person's other engagements will be relevant, it doesn't follow automatically from the fact that a person is otherwise self-employed that a particular engagement is not an employment. So the authority for that is Fall and Hitchin. The test for employment in the ready-mix concrete case is also relevant. McKenna J in that case laid out three minimum requirements for a contract of employment to exist, namely mutuality of obligation between the individual and the client, sufficient control by the client to make him the master of the individual, and the requirement that the other terms of the contract are not inconsistent with the terms of a contract of employment. The more controversial of those requirements are the final two. Control is described further in the ready-mix case as control over what needs to be done, the way in which it's to be done, the means to be employed in doing it, so how the work is to be done, and the time and place where it shall be done. But there doesn't have to be control in every sense, and the nature of the control will vary depending on the job. There has to be a sufficient framework of control to make the client the master of the individual. As for the requirement that the other terms of the contract are not inconsistent with a contract of employment, McKenna J gave 5 examples of different contracts. I don't have time now to run through them all. He concludes that although control is a necessary feature of an employment contract, it's not determinative, and if there are other provisions which are inconsistent with a contract of employment, then there won't be one. So let's take a brief look at how these cases were applied to the facts in the recent FGT cases. So in Miss Adams' case, the engagement was to present the Kaye Adams programme on BBC Radio Scotland, which ran for 3 hours on weekdays. Her professional circumstances included that she performed a variety of professional services, including radio and TV presenting, writing non-fiction columns and books, internet advertising on Instagram and Facebook, presenting at events and awards ceremonies, and she worked for a variety of different media organisations. The BBC was only one of those organisations. The FGT decided that Miss Adams was in business on her own account, taking the approach prescribed by the Court of Appeal in Hall and Lorimer in relation to the following facts. That Kaye Adams had her own professional identity and reputation independently from her BBC presenting, in particular from appearing on ITV's Loose Women, in relation to which she was self-employed. That although the BBC had ultimate editorial control, it didn't have control over her other engagements, it didn't have first call on her services or require written consent for non-BBC engagements, and the BBC facilitated her engagements with other organisations such as ITV because they enhanced her profile and therefore the BBC show's ratings. Furthermore, in applying the final requirement of the ready-mix concrete test, the tribunal decided that there were other terms of the contract which were inconsistent with a contract of employment, such as the lack of provision in the contract for holiday, maternity leave, sick pay or pension rights. Miss Adams wasn't entitled to a performance review, which wasn't subject to the formal procedures applicable to BBC employees when a change was made to the nature of their work engagements. She wasn't entitled to apply as an insider for internal BBC roles. The fact that she used her own smartphone and iPad to work on and to record shows, although I think the tribunal gave this very little weight, and the fact that she bought her own clothes. In Lorraine Kelly's case, what the media has picked up on is that the tribunal found she was an entertainer on her 2 morning shows for ITV, Lorraine and Daybreak. Applying the ready-mix concrete requirements, the tribunal found that Miss Kelly was not under a sufficient degree of control by ITV in the sense required by that case, although ITV did have editorial control over the shows. Miss Kelly determined the format, the content, the film locations, and chose her co-presenter, and that other terms of the contract were inconsistent with a contract of employment, such as the fact that she was not entitled to sick pay, pension, holiday, appraisals, or training. There were no requirements for her to attend meetings outside the show. She wasn't considered part and parcel of ITV. She had her own personal Twitter account and email. And in taking the approach required by Hall and Lorimer, the tribunal decided that when standing back and looking at the picture as a whole, Miss Kelly was in business on her own account. The relevant facts on which the tribunal based that part of the decision were that she was hired for her brand and individual personality and ability to increase the ratings and was judged by ITV solely on that. And she carried out a variety of other work, not for ITV, from writing to designing and advertising a fashion line. So her case in those respects is very similar to Kaye Adams, including the conclusions of the tribunal. Coming on to Christa Ackroyd's case, the facts seem to have been very different to those of Lorraine Kelly or Kaye Adams, in that Christa Ackroyd was a news reader on Look North. She was on a rota and she was very restricted by the script and the show. She had little to no free rein. She wasn't hired for her personality or media presence in other engagements. Neither of those are required for a straight-laced news programme. Her non-BBC income was de minimis in comparison to her BBC income, being 2 or 3% of that. The BBC had first dibs on her time, and she was required to obtain written consent for the BBC for non-BBC engagements. Her contract was 7 years long and was preceded by a 5-year long contract, and she was given a clothing allowance and BBC training. So it would be a completely different picture that's painted by the accumulation of these details under Hall and Lorimer, and the application of the ready-mix concrete test would also be to a completely different set of facts. One final point in particular to highlight in relation to the test for control is that even a very highly skilled person is not expected to be controlled by their employer in how they perform their task. Therefore, the courts have held that that fact doesn't carry decisive weight in deciding whether there's a sufficient framework of control. So the example that's always given is that of a brain surgeon who is highly skilled but can nevertheless be an employee of a hospital. And the same could be said of an IT guru. So if I can summarise now by reference to all of these 3 cases where that leaves us, point number 1, the facts of Albertel and Atoll House are unique and will no doubt be rare. Number 2, even a highly skilled professional may be found to be in a master-servant relationship with a sufficient degree of control by the client, where the provisions of the hypothetical contract are not inconsistent with an employment and where the person is not in business on their own account. And if so, they would be an employee under a hypothetical contract constructed under Section 49 of ITEPA. Since the approach is not a tick-the-box exercise and the terms of the written contract can't be taken as read, you can never be sure of a person's employment status. Thank you for listening.